Larson. Counsel, would you state your appearances for the record?
Ben Van Noy, on behalf of the Utah County Sheriff's Office.
Ron Wilkinson, Your Honor, on behalf of the father, B.J. Larson, who's present via separate WebEx link with me.
And Steve Christensen for the mother, Your Honor.
Very good. Thank you.
Daniel Ayer, private guardian ad litem. And Your Honor, I would ask that this hearing be closed so that in the past, the observers have communicated the proceedings to the minor children.
I'm sorry, can you clarify that?
I would ask that the hearing be closed to the public, just because, and in the past, observers or other individuals have communicated the proceedings to the minor children, and I believe this is the topic of today is sensitive enough that the minor children should not be exposed to it.
Very good. Thank you. Mr. Wilkinson, do you wish to be heard on the guardian ad litem's request?
Yeah, no, we don't have an objection to that. We did note on one of the TikTok videos that there was a third party from our last hearing that was keeping the young man apprised of what was going on during the hearing, and that was streamed live. It was concerning. The young man made a comment shortly thereafter. You don't understand the power that I have. 2,000 people are watching.
Thank you. Mr. Christensen?
Your Honor, I did not understand this to be a substantive hearing. I thought the notice I received was that this was to be a scheduling conference.
We're also addressing the Utah County Sheriff's Office's motion to clarify the writ of assistance.
I didn't understand that.
Okay, thank you. With respect to the motion to close the hearing, the request is denied. I will order that neither of the parties communicate the substance of today's hearing to the children, and I will also order that they not direct or permit others to do that on their behalf. Very good. Let's turn to the Utah County Sheriff's Office's motion to clarify the writ of assistance. I've read the papers filed in support of that motion. By way of explanation of how we got here, on November 30th, 2022, the Domestic Commissioner recommended that one petitioner, Jessica Laura Zart, who I'll refer to as Jessica, be held in contempt of court for disrupting the reunification process to which she had agreed and for interfering with parent time exchanges. Two, that respondent Brent Joel Larson, who I'll refer to as Brent, receive make-up parent time and be awarded temporary custody of the minor children immediately. And three, that the children be enrolled in Turning Points. On December 1st, 2022, Jessica filed an ex parte motion for temporary restraining order seeking to stay the Commissioner's recommendation. The same day, this court stayed the Commissioner's ruling until Brent and the guardian ad litem could be heard in opposition. On December 5th, 2022, the court granted Jessica's motion for temporary restraining order and scheduled a preliminary injunction hearing for January 20th, 2023. The court ordered that Brent's make-up parent time be exercised beginning December 9th, 2022. Jessica did not produce the children for the exchange as ordered. In response, Brent moved the court to issue a writ of assistance. On December 16th, 2022, this court issued the writ of assistance. The purpose of the writ was to enforce the court's order authorizing make-up parent time between Brent and the children. The parties appeared for the preliminary injunction hearing on January 20th, 2023. Both were permitted to present evidence and to confront and cross-examine witnesses. The court had ordered Jessica to bring the children to the hearing. Jessica did not produce the children as ordered. On January 23rd, 2023, the court issued its 35-page ruling and order denying Jessica's motion for preliminary injunction and order of temporary custody. That's docket number 107. In the injunction ruling, the court ordered that Brent have temporary custody of the children subject to conditions. These conditions included that 1, the children reside separately in the homes of designated paternal uncles, and 2, Brent's parent time with the children be supervised. This was a temporary order of custody pending resolution of Brent's petition to modify. The court ordered Jessica to exchange the children at the Salem City Police Department at 5 p.m. on January 23, 2023. Again, Jessica did not produce the children for the exchange as ordered. To give effect to the order of temporary custody in the injunction ruling, this court ordered that the prior writ of assistance remain in full force and effect. Brent asked the Utah County Sheriff's Office to execute the writ of assistance. In response, the Utah County Sheriff's Office filed a motion asking this court to clarify both the writ of assistance and the injunction ruling. Specifically, the Utah County Sheriff's Office asked the court to clarify 1, the time at which the sheriff can execute the writ of assistance, 2, that the sheriff has authority to execute the writ but maintains its discretion on the manner and method of execution, including the discretion to determine whether execution is possible and reasonable. 3, into whose custody and where the children are to be taken upon execution of the writ of assistance. And 4, that in executing the writ of assistance, the sheriff may use reasonable force necessary to compel compliance, but must use only those means that are least traumatic for the children. Neither Brent nor Jessica responded to the sheriff's motion for clarification, and the sheriff requested this hearing. With that background in place, Mr. Van Noy, I'll hear from you first.
Thank you, Your Honor, and forgive me if my voice gives out. I'm recovering from a head cold. My client definitely recognizes that this is a bit of an unusual request, but we appreciate the court hearing this motion, especially given the sensitive nature dealing with the children. I won't reiterate those 4 main points that the sheriff would request clarification on, but it has come to the attention of the sheriff's office, and my client feels it imperative to inform the court that in the past couple of weeks, 2 different police agencies have referred criminal charges to their respective prosecuting agencies against Mr. Larson, including pointing a gun at the children's head, dealing in harmful materials with the children, threat of violence, aggravated abuse of a child, sex abuse of a child, object rape, and sodomy of a child. This information is not intended to show the court that the sheriff is not willing to respond to the court's orders. But again, the sheriff felt it was imperative that the court be apprised of this situation as it happened in the past week or so.
And that's new. That's new information to me. Can you tell me who the complainant is and when the complaints were made? I'd also like to know if you know whether these allegations are different from those that formed the basis of Jessica's petition to terminate parental rights filed in 2018.
I do. What I do know is that Lone Peak Police Department was involved in Harriman Police Department. Unfortunately, Your Honor, I do not know the timing of the complaint, who the complainant was, or whether it was similar to the previous allegations. What we were able to glean from reaching out to those police agencies was that those investigations and reports were submitted within the past week or so to the appropriate and relative prosecuting agencies. Unfortunately, Your Honor, that's the only information I have at this time.
And is one of those agencies the Utah County Sheriff's Office?
I don't believe so, Your Honor. The Lone Peak misdemeanor, and And I failed to mention that my client, Sheriff Mike Smith, and Chief Deputy Sean Shipman are on, and if it would be appropriate, if they knew anything further, if they could chime in. The Harriman charges with the Salt Lake District Attorney's Office, and I am not certain if the misdemeanor charges with the Utah County's Attorney's Office is a misdemeanor, so it is possible that it is in the Justice Court.
And can you tell me what the charges are again?
Yes, from the Lone Peak Police Department, misdemeanor charge for pointing a gun at the children's head. That was the information that was provided. I know that's not the actual terms of the potential charge. Those were the facts that supported that charge or that referral. And from the Harriman Police Department, dealing in harmful materials, threat of violence, aggravated abuse of a child, sex abuse of a child, 3 referrals for counts of object rape and sodomy of a child. And again, the Sheriff's Office recognizes those are just allegations and potential charges, and they haven't even been screened, is my understanding to this point, but felt it was imperative to inform the court.
Do you know whether the investigations are complete? It sounds like they are. I mean, if a referral's been made.
That's my understanding. Whether some ongoing or follow-up investigation is going on, I'm not sure.
Okay, I appreciate that. Go ahead.
Other than that, Your Honor, you are aware of the 4 main points. I won't belabor those points, but emphasize that given the sensitive nature and social media and media reach on this case, the Sheriff's Office would just like to convey that they are proceeding with caution, which is the purpose for coming before the court today. And we appreciate your time in helping us understand the best way to execute this writ, if that's the court's orders at the end of this hearing. Thank you.
Very good. Thank you. Mr. Christensen, I know Ms. Zart filed no formal response to the Sheriff's Office request for clarification, but I'm happy to hear anything further that you'd want me to know today.
Thank you, Your Honor.
By the way, is your client with you? I don't see her joining.
She is not, and it's my fault. I thought, I was mistaken that this was just a scheduling conference, and I apologize for that.
No, that's all right. I just wanted to make a record whether she was here or not. I didn't see her. So go ahead.
Thank you, Your Honor. The disclosure of pending investigation by the criminal authorities is new information to me, which, I think that does bear on whether the clarification should be issued here. And I believe several of those charges are new. Obviously, the object rape and the sodomy, those claims are somewhat similar to what was investigated under the juvenile court. But I don't know that they're exactly the same. The other charges appear to be new to me. I'm not aware of any opportunity for this court or for the juvenile court to consider those matters, and I would ask the court to delay the ruling today in order to determine, first of all, what is the procedural status of those criminal charges and what is the effect of those on this court's earlier ruling.
Very good. Thank you. Mr. Wilkinson.
Thank you, Your Honor. We were aware of an investigation. They reached out to my client. I would remind the court, as Mr. Van Noy indicated, that there were no charges. My client fully cooperated with both of those investigations. The allegations took place over half a dozen years ago or so. Many of the allegations are the same. Some seem to have morphed, including some that seem to be made up out of whole cloth. I would note that my client has had no unsupervised contact with the children since these allegations. And so everything would clearly predate that, Your Honor. I would also note, Your Honor, this has been a pattern. It's something that was raised throughout the juvenile court, which is one of the reasons that it took so long, is there was always a new investigation, there was always a new allegation, there was always something coming down the pike. It seemed to work a bit at that time, and it seems to be sort of a modus operandi in terms of what's happening today. Certainly, my client remains innocent until proven guilty, which we don't believe the charges will even be brought. And we certainly want to protect the children from their current environment. We don't oppose, Your Honor, the requests of the county attorney with respect to their having discretion in the time, but we do believe that time is of the essence, nor their authority with respect to the manner and method, although we are concerned about their having discretion of where execution is possible or reasonable. Into whose custody, Your Honor, I think the order is clear. That would be with the father. The father stands prepared, as do the uncles, to coordinate with the county attorney's office with respect to that. And we certainly support the request, the fourth request, that it be done in the manner which would be least traumatic for the children. We appreciate the court's efforts to try to make an alternative, less volatile approach work, but where the children and the mother did not cooperate with that process, I think we're left with the writ of assistance being our primary method. I would, in closing, Your Honor, just note the concern that we have with respect to the tone of the older boy, and that's the quote that we used before, where he says clearly, quote, "You don't understand the power I have. 2,000 people are watching." Our concern, Your Honor, is not just the media and the impact with respect to that of social media, but also with respect to the message that this is sending to young people throughout the state and throughout the country that would suggest that all they need to do is get a TikTok account and the rule of law no longer applies. Certainly it does. Certainly the court's power needs to be executed, and we appreciate the efforts of the county attorney to do so.
Thank you, Mr. Wilkinson. Mr. Eyre?
Yes, thank you, Your Honor. This recently, I've had a conversation with the family therapist, and one recommendation that she had, and that I support, is that my understanding is that the current order is that the children go to one of the uncles in separate homes.
Yeah, with the daughter being able to choose first.
Yes, I would just add that I think it would be appropriate for the court to that if one of the uncles is unavailable, that another relative could be substituted in with consulting with myself and the family therapist.
Did you have someone in mind?
So we're not. It would probably be another aunt or uncle not listed in the order. Let me see. Possibly a grandmother, not the grandmother that the respondent lives with, but another grandmother.
Would that be the grandmother where the children went for Thanksgiving?
No, that would be a different grandmother.
Okay.
And I would just because of the nature of this these proceedings, it would be beneficial to have the ability to make accommodations if needed, and not be in a situation where the children have been picked up by the sheriff's department and not have a place to go because an uncle's not available at that moment.
Right. Do you have any indication that either paternal uncle has withdrawn their consent to participate in the way that it was represented to me before?
Not directly. My understanding is one of the uncles may be out of town for a while, for a couple weeks, and we wouldn't want that to stop this process.
And the uncles stand ready and willing currently to do so. I would note with the verbiage, Your Honor, that one is a bit concerned that if it's designated it needs to be at their home, that does not give them the flexibility in case there are protests or other challenges that they could certainly go to a third location. I would note that apparently today there's supposed to be a protest of the guardian ad litem's office, and we certainly don't want the children put in the middle of those types of things. So we would like, of course, the uncles to have some discretion where they would be with the children.
Thank you. Mr. Christensen, anything further? I think you may be muted there.
Thank you, Your Honor. This is all new information to me, Your Honor. I don't know exactly who's being proposed and what the circumstances are. I would just say that I think for the court to actually make an order, there would need to be some kind of a proposal that is specific so that we could address those rather than just sort of a free-for-all.
Thank you. I know Ms. Zart is not here today. This writ issue is an important one. I believe the hearing was noticed up for this. Do you want a moment to try to contact her and see if and speak to her before I issue a ruling? Mr. Christensen, are you there?
Yes. Do you want me to call her, Your Honor?
I'm sorry, you were muted. I didn't hear your response. Do you want a minute to talk to her?
Yes, I said
Okay.
I would like to. Thank you.
Great. We'll just be in recess for a minute. If you want to just get her to join, that would be fine, or talk to her, and then let me know when you're ready.
Okay, thank you.
Thank you. Mikkel, are you there?
Yes, back on the record.
Great, thank you. We'll go back on the record in the matter of Zart versus Larson. Mr. Ayer, are you there?
Yes, Your Honor.
Very good. The record should reflect that all counsel are present. Mr. Christensen, were you able to speak with your client?
I have, and she's joined, Your Honor.
Great.
I would just indicate to the court, she said that when the sheriff's office came to the home, that she opened it.
I'm sorry, you're breaking up on me. I'm hearing about every other word.
Let me see if I can get closer to the mic.
That's much better. Thank you.
Okay. She wants to indicate to the court that when the sheriff's office came to the home, that she let them in. There was no obstruction of them executing the court's writ, but this comes down to the children's refusal. She also requests the court to hold an evidentiary hearing on whether it is in the children's best interest to use the force that is being requested in the writ. There certainly has had an evidentiary hearing on the question before the court before, but we have not had an evidentiary hearing on the best interest of the children. Whether this show of force is best interest, I certainly think it would be of benefit for the court to hear from experts in this regard to do that before issuing assistance.
Thank you. Mr. Wilkinson, anything further from you?
No, thank you, Your Honor.
Very good. Mr. Vanoy, this is the sheriff's motion. You have the last word. Anything further?
Thank you, Your Honor. I was able to clarify during that recess that the Utah County Attorney's Office is screening that misdemeanor charge from Lone Peak, but it is still in the process of being screened. Also, to clarify, it's my understanding that the Salem Police Department attempted the original writ of assistance, and that the Sheriff's Office has not yet attempted to enter into the home. Just as a clarification. Other than that, nothing further, Your Honor. Thank you.
Given that the Harriman Police Department is investigating these additional allegations, my understanding is they would be in Salt Lake County, correct?
That's my
And
understanding, Your Honor.
the referral's been made to the Salt Lake County District Attorney's Office.
That's correct.
Okay, thank you. If you'll give me just a moment to review my notes. Counsel, thank you for your patience. This matter comes before the court on the motion of the Utah County Sheriff's Office to clarify the writ of assistance. As I indicated in my prior ruling, the court has authorized the intervention of the Sheriff's Office in this action solely for the purpose of filing this motion. At its essence, the sheriff's motion to clarify is a motion to acknowledge the separation of powers between the judicial and executive branches of government. Article 5, Section 1 of the Utah Constitution provides the powers of the government of the state of Utah shall be divided into 3 distinct departments: the legislative, the executive, and the judicial. And no person charged with the exercise of powers properly belonging to one of these departments shall exercise any functions appertaining to either of the others, except in the cases herein expressly directed or permitted. As a person charged with exercising powers belonging to the judicial branch, this court has original jurisdiction in all matters except as limited by the Utah Constitution or by statute, and power to issue all extraordinary writs. That's under Article 8, Section 5 of the Utah Constitution. By statute, this original jurisdiction includes authority to issue all extraordinary writs and other writs necessary to carry into effect the district court judge's orders, judgments, and decrees. That's Section 78A-5-102, subparagraph 2. The judicial authority to issue writs includes the power to direct in general terms how the writ can be executed. For example, in issuing a writ of assistance, the court may authorize the executing officer to enter private property as necessary to take custody of the minor children, restrain any person who attempts to prevent the sheriff from carrying out the writ, use force reasonable under the circumstances to gain entry into private property, including a residence if there is reason to believe that the minor children are within, and after notice of the sheriff's purpose and demand for admission, there is no response or the sheriff is not admitted within a reasonable time, and the court may authorize the executing officer to execute the writ at any time or only between 6 a.m. and 10 p.m., for example. The Utah County Sheriff is an officer of the executive branch. As an officer of the executive branch, the sheriff is charged by statute with making all lawful arrests and obeying the lawful orders of the Utah Supreme Court, the Utah Court of Appeals, and other courts of record, including the district court. Thus, issuing writs necessary to carry into effect a court order and directing in general terms how the writ may be executed is a judicial function performed by the district court. But executing a judicially issued writ is an executive function performed by the county sheriff. So long as the sheriff acts within the judicially defined parameters of execution, the sheriff has broad discretion to determine when, where, and how the writ will be served. For example, the fact that entry upon private property is judicially authorized does not mean that the sheriff is required to execute the writ on private property. Within a judicially determined window of execution, for example, 6 a.m. to 10 p.m., the sheriff has broad discretion to decide on what date and at what time the writ will be executed. While reasonable force and restraint of obstructing persons may be judicially authorized, the sheriff has broad discretion to determine what force is reasonable under the circumstances and to decide whether or in what manner an obstructing person should be restrained. Of course, this broad executive discretion does not include the discretion to decide whether the writ of assistance is executed. Section 17-22-2 of the Utah Code places a legal duty on the sheriff to obey all lawful writs. But as an executive officer, the county sheriff, acting within the writ's judicially defined parameters, decides when, where, and how the writ is executed. It would be a violation of the separation of powers in Article 5, Section 1 of the Utah Constitution for the judicial branch to intrude upon this executive discretion. In summary, to the extent that the Utah County Sheriff's Office's motion seeks clarification of the judicially defined parameters of execution, the motion is granted. In executing the writ, the county sheriff is authorized to 1. Enter private property as necessary to take custody of the minor children. 2. Restrain any person who attempts to prevent the sheriff from carrying out this writ. 3. Use force reasonable under the circumstances to gain entry into private property, including a residence, if there is reason to believe that the minor children are within, and after notice of the sheriff's purpose and after demand for admission, there is no response or the sheriff is not admitted within a reasonable time. 4. The sheriff is authorized to execute the writ only between the hours of 6 a.m. and 10 p.m. And finally, upon executing the writ, the children shall be taken to the separate homes of their paternal uncles, as previously authorized and as selected by the children, where Brent shall have supervised custody consistent with the court's prior ruling and order. With respect to the issue of homes, wherever the paternal uncles are residing is a place where the children can be taken. And finally, if the children flee the residences of the paternal uncles, the sheriff's office is authorized to take the children to juvenile detention until the children can be released to the supervised custody of Brent consistent with the prior ruling and order. So long as the sheriff acts within these judicially defined parameters, the Utah County Sheriff has broad discretion to determine when, where, and how the writ of assistance is executed. Finally, to the extent that the Utah County Sheriff's Office's motion seeks an order authorizing the county sheriff to decide whether the writ of assistance is executed, the motion is denied. As stated, the Utah County Sheriff, as with all sheriffs in the state, has a statutory duty to execute all lawful writs. With that substantive ruling being made, I'm not sure who's not muted right now, but if you're not muted, if you could do that. It's got a lot of people joining today. Please mute yourself. Very good. With that substantive decision being made, new information has come forward today regarding allegations of serious allegations of abuse. By way of history, in 2018, allegations of sexual abuse were brought forward at that time as the basis for Jessica's petition to terminate parental rights in the juvenile court. Those allegations of sexual abuse were the subject of litigation for 3 years in the juvenile court. And on the eve of the case being scheduled for trial, Jessica moved to dismiss her petition on the ground that evidence of abuse was insufficient. And that's reflected in the juvenile court's order. It appears that these allegations of sexual abuse and other kinds of abuse against the children at the hands of Brent have been put forward after this court's ruling and order regarding temporary custody being awarded to Brent. Importantly, as I understand it, the 2018 allegations were screened, I believe, by the Utah County Sheriff's Office with the declination of prosecution. These new allegations have implicated the jurisdiction of a separate county attorney's office, the Salt Lake District Attorney's Office, which would suggest that these are new allegations occurring outside of Utah County. It's represented today by the Sheriff's Office that a referral has been made to the Utah County Sheriff's Office from the Lone Peak Police Department for a Class B misdemeanor offense. It's unclear to me whether that was a part of the 2018 allegations or not, or if that's a new allegation.
Your Honor, if I may interrupt, I apologize. I believe it was sent to the Utah County Attorney's Office, and it would be a Class A misdemeanor, is my understanding.
I appreciate that. Thank you.
And Your Honor, the original declination was from Salt Lake County. Is that where the parties resided during that period of time?
Thank you. So it was the Salt Lake County Attorney's Office that declined?
Yes, Your Honor.
Okay, I appreciate that. Thank you. And that would reflect that this case was originally filed in the Salt Lake in the 3rd District Court and only transferred by way of a transfer of venue to this court in September of 2022. Given the new allegations that have come forward, that police investigations have been undertaken, apparently in which Brent has participated, and that these cases have been referred to the Salt Lake County District Attorney's Office for screening, as well as the Utah County Attorney's Office for screening of a separate complaint. I'm going to vacate the writ of assistance until further order of the court and await the decision of the Salt Lake County Attorney's Office or Salt Lake County District Attorney's Office in the screening of these charges. In the event that a declination of prosecution is the result of that process, Mr. Wilkinson, you may move the court to reinstate the writ of assistance. If charges are filed, any party may seek further relief from the court, but the writ of execution is vacated until further order of the court. to allow the criminal justice process to take its course, at least through the charging decision. And Mr. Van Noy, I will look to you to prepare an order consistent with my decision as to the substance of the sheriff's office's motion. And counsel, I'll refer my I have written notes to assist you in the preparation of that order. Mr. Christensen, I'll look to you to prepare an order vacating the writ temporarily and provide that to Mr. Wilkinson for his review, as well as the guardian ad litem. I'd like to turn now to the Rule 16 scheduling conference. By way of background, Brent filed his petition to modify custody on May 2nd, 2018, seeking a change in custody. He alleged a substantial and material change in circumstances, including that Jessica had engaged in a campaign and a course of conduct of falsely accusing the respondent of abusing the minor children, and had induced the minor children to make disclosures about allegations of abuse which are false. Jessica answered the petition on May 23, 2018, denying that she engaged in a campaign of or inducing the children to make false accusations and affirmatively alleging that Brent has sexually abused his daughter and has been doing so for years. That's in her answer, paragraph 1. After Jessica answered, the court issued the standard notice of event due dates, setting out discovery deadlines. Under the notice, fact discovery in this case on the petition to modify closed on December 31st, 2018, and expert discovery closed on May 6th of 2019. On or about the same date Brent filed his petition to modify in May 2018, Jessica filed in the juvenile court a petition to terminate Brent's parental rights. The basis of the petition was that Brent had sexually abused the minor children. The parties litigated the petition to terminate parental rights for 3 years. Then, as I stated on the eve of trial in June of 2021, Jessica moved to dismiss the petition because the evidence of abuse was insufficient. Counsel, given this procedural history, the lengthy period of litigation in the juvenile court about the central question of abuse that animates this case, and the expiration of both fact and expert discovery deadlines in this case, the court proposes that Brent's petition to modify be scheduled for trial. I indicated that I would like the parties to be prepared to speak to the objectives of Rule 16, and I'd like to begin with Mr. Christensen. I think you may be muted there. I can't hear you. I'm sorry.
You're right. I request that we be given a period of discovery. There's been 4 years past since the closing of discovery, and to set this for trial without any opportunity to engage or disclose experts, I believe would prejudice the parties and really prejudice the court from being able to make a decision based on the facts as they exist today, 4 years later. I think there is one issue, and that is abuse that the court has indicated was litigated in the juvenile court, but there are other issues that relate to a petition to modify that were not litigated in the juvenile court. And
what are those? I've reviewed the petition and the answer. What other issues are there?
Well, the best interest of the children and all of the factors that go into a custody decision in terms of whether the court should modify custody are relevant to a determination of custody and parent time. And those, there's been a custody evaluation that dealt with some of these issues in the juvenile context, but that is a stale evaluation, and I don't know if that evaluator is available to testify before the court. So for today's purposes, we would need to either see if she's available or, and be able to obtain some kind of an update of that evaluation in order to bring all of the custody factors before the court. So I think those are the primary issues we would want the court to consider.
How long?
Well, I mean, I think it's going to depend on the custody evaluation process. If a new evaluation is undertaken, it's going to depend on who is chosen, what their availability is, and how fast they are able to bring the parties' evidence together and make a report to the court. But I would agree that we should make that decision within 30 days in terms of, is there going to be a new evaluator or the same evaluator, and be able to present to the court the time frame of those experts.
Other than expert discovery, is there any further discovery that you would want to conduct? I mean, I'm very troubled by the fact that, original discovery period has long since lapsed. And apparently, I know, Mr. Christensen, you came into this case much later, but apparently squandered. I don't know if anybody did any discovery, but we're done, and we've been done for years.
Well, as the court knows, we came in August of 2022, and fact discovery had been closed for 3 years, so something, as the courts indicated, 3.5 years. So there was no opportunity to do discovery. It was closed. What we're asking the court to determine today is that the court should reopen fact discovery given the passage of time. We now have children that are 4 years older, and the issues pertaining to them are different than they were, and the facts are different than they were 4 years ago. So I would ask the court for a 90-day period for depositions and just traditional fact discovery outside of what I've indicated relating to the custody evaluation process.
Very good. I appreciate that. Mr. Wilkinson?
Thank you, Your Honor. The parties elected a process to go through. Part of that process was to elect what we believe would be a second or third reunification therapist, determining such. And we believe that we're prepared to go to trial, and that further delays will only be worse for both the parties, and more importantly for the minor children. We're troubled by the fact that by bringing new allegations again, because this was the same thing that was done repeatedly in the juvenile court, that it further delays the process and the execution of court orders. And we would call to the court's attention Rule 16. It indicates in subparagraph D, if a party or a party's attorney fails to obey an order, and then there's other suggestion, the court may take any action authorized in Rule 37B. And 37B, with the motion for sanctions, the court would need to find that the failure was substantially justified. The court may impose appropriate sanctions, and that includes paragraph 1, deem the matter or any designated facts to be established in accordance with the claim or defense. Prohibit the disobedient party from supporting or opposing designated claims or defenses, and we believe, or 4, dismiss all or part of the action, strike all or part of the pleadings. We're in a position now where the mother has clearly failed to abide by the orders of the court. There's been findings with respect to that, and continue to reward that type of behavior, Your Honor, we think is not helpful for the rule of law. More importantly, is not helpful for these children or for the father. And so we believe the mother's pleading should be stricken. A best interest hearing can be set. The court already has the benefit of a court-appointed guardian ad litem, a court-appointed reunification therapy, and other experts that have been designated or relied upon. And we believe that that trial on that issue should be set as soon as reasonably possible.
Can I just ask you the same question I asked Mr. Christensen? I'm very troubled by the fact that this case had discovery deadlines in place. Apparently, no one did anything in terms of depositions or fact discovery, and now here we are with that. Why was that? Help me understand why nothing happened.
I wasn't there either, Your Honor. I've been involved longer than Mr. Christensen, but I was not the attorney at the time of the original process. My understanding is, Your Honor, that certainly the termination of parental rights would be dispositive, and so that's where the primary focus was. There was a separate guardian ad litem there, and the parties chose and put their efforts there. The parties elected to have an evaluator, and that was done in the juvenile court. And then ultimately, the proceedings, as Your Honor indicated, were dismissed. Subsequent to that, Your Honor, and I think again significant, is the parties elected a process to resolve the issues, to obtain whatever information was necessary, and that was the appointment of the most recent reunification therapist. My client patiently went through that process, waited over a year in going through that process and having parent time, and as the evidence the court's already received would indicate, it was a slow and methodical process. He trusted in that process. He trusted in the rule of law, and now we are where we are.
Okay.
And,
So in summary, it seems to me that the parties in some ways just stood down, right? That they were pursuing a reunification step-up plan that both parties agreed to, that took some 18 months, if I'm correct. And so the petition to modify just sat, I guess.
Oh, Your Honor, the hope was to be able to move forward and act like parents and not like litigants, but they elected that process knowing that there were two tracks. One track was a potential resolution, and the other track was the opportunity to be heard at trial. Track A has failed. We're now prepared for track B, Your Honor.
Okay, very good. Mr. Eyre?
Your Honor, I don't have much of a dog in this fight in the regards of the timing of discovery. I would note that discovery would have also been conducted in, and I think it was mentioned in juvenile court from after the filing of the petition to modify. The petition to terminate parental rights was filed. The discovery would have been conducted in both cases. But I believe that primarily the focus being on the juvenile court and the termination petition, that was where the focus of discovery was also. And so I don't think it's quite, it's not quite so clear as to what a failure of discovery of the parties to exercise that right. It was just conducted in a different court.
Okay.
And evidence of that would be the fact that in juvenile court, there was a request for Dr. Christie's evaluation, which was thoroughly conducted and completed in an evaluation as part of the juvenile court termination petition.
Okay, thank you. Council, I appreciate your thoughts on how we move forward. Again, the purpose of a Rule 16 scheduling conference, among them, is expediting disposition of the action, establishing early and continuing control so that the case will not be protracted for lack of management, discouraging wasteful pretrial practices, and ultimately improving the quality of trial through preparation. as I've thought about how to move this case toward trial, which I really think that's what needs to happen, the disputed issue between the parties is whether or not the children have been subjected to abuse at the hands of Brent. That question has never been adjudicated on its facts, and it continues to animate the dispute today. I'm not persuaded that more fact discovery is required. The parties understand the basis of these allegations. Simply not persuaded that we need to do anything more in that regard. But I am going to authorize the reopening of expert discovery. I will order, we do have the reunification therapist who has testified at length in the preliminary injunction hearing. And by rule, her testimony may become a part of the trial record. But I agree with Mr. Christensen that a significant amount of time has passed. The children are older. It seems to me that a new custody evaluator may be of significant value going forward to both parties. That's one way to proceed, is by stipulation to an update of the custody evaluation by the person who did the original one. I would hope that we would just continue with that person who has background in the case, but he or she may not be available. But I'd like to reopen expert discovery. Within 14 days, the parties will together approach the original custody evaluator to determine his or her availability to provide an update to the custody evaluation. The parties will share the costs of the evaluation. And counsel, I'd like you to meet and confer about a discovery schedule after we know that missing piece. And I would like a specific expert discovery deadline in place, which will conclude the discovery in the case. I want it expedited. It is not in the best interest of the children to have this case continue to languish. And the purpose of today's conference is to expedite the disposition of the action. And so I want you to be aggressive in that deadline, meet and confer about what it should be. And if you need my help in resolving any dispute about the deadline, let me know. It should not, in my view, exceed between 90 and 120 days, 120 days being the default discovery deadline for experts under Rule 26. But within those parameters, I'll allow you to set whatever deadlines you think are appropriate, and I trust, given your experience, that you'll be able to meet and confer and get a discovery schedule in place. Finally, I would like to have built into that order a status conference at the close of expert discovery, and you can contact the clerk and get that date on the calendar. After expert discovery is closed, we can schedule a trial at that point. That having been said, there's also dispute in this case about the merits of a reunification camp called Turning Points. I've reserved ruling on that question, suggesting to the parties that an evidentiary hearing may be necessary to determine the efficacy of such experiences. That is a subject on which experts may opine. If you intend to call experts on that issue or any other issue, you should disclose your experts within 14 days of today's date. And from that date forward, conduct your depositions or request reports within the time frame set out in Rule 26. Finally, Council, I've thought about, in terms of improving the quality of trial. Jessica insisted at the evidentiary hearing that the children be given a voice in this custody dispute, but did not produce the children in court so that they could speak, despite this court's order that they be produced. Whatever fear Jessica may harbor that the writ of assistance would be executed upon the children appearing in court as witnesses is, as a matter of law, unwarranted. A person who, under court order, appears in court as a witness is exempt from arrest in a civil action while going to the place of attendance, necessarily remaining there and returning therefrom. And that's under section 78B-1-138 of the Utah Code. I'd like the parties to meet and confer regarding section 30-3-10, subparagraph 5 of the Utah Code, which sets out the parameters of when a child may testify in a custody dispute. As you both know, that occurs in an in-camera setting under questioning of the court. It can only occur when there are extenuating circumstances that would necessitate the testimony of the child to be heard, and there is no other reasonable method to present the child's testimony. This case does present some unique facts in that regard. While the desires of children may be considered in the custody question, those expressed preferences are, as a matter of law, not the single controlling factor. And the consent of the parties may be obtained, but is not necessary if the court finds that an interview with a child is the only method to ascertain the child's desires regarding custody. It's clear, at least from Jessica's point of view, that the children have a desire to be heard, but state law places significant limitations on children testifying in their parents' divorce case for obvious reasons. There can be great harm experienced by children in doing that. And so section 30-3-10 places appropriate limits by legislation, places appropriate limits about when children are permitted to testify. In your conference, I'd like you to meet and confer about that issue and suggest and reach an agreement as to whether or not this is the kind of case where an in-camera interview with children would be appropriate. And we can and reach a stipulation about that. If you can't, I'm happy to be involved in assessing that issue further as well. Finally, in your discovery conference, I would like you to establish a motion cutoff deadline. And then we'll have our status conference built into the order. And that, council, should move us toward an expedited trial setting. My intent is not to grant any extensions of time for expert discovery. And so I'm leaving those deadlines within your able hands within the next 120 days. Of course, we'll assess the availability of the custody evaluator. And if she's unavailable, you can certainly contact me and we can, or you can propose a stipulated expert discovery schedule that accommodates that availability. So I leave that in your able hands. I would like that discovery conference to occur within 14 days of today's date. I'd like it to occur in person. And by in person, what I mean is you can appear remotely, but I'd like you to see each other rather than just do this on the telephone. Mr. Wilkinson, will you prepare the order from the scheduling conference today?
I will, Your Honor. I will, in candor to the court, indicate my concern with respect to our office's ability to comply with that. I wish this was my only case, Your Honor. I wish I didn't have a mediation that started an hour ago and I could go on, but I don't know what our availability is going to be to meet those deadlines.
Which one?
The 14-day deadline, Your Honor.
I don't want to be draconian, but we need to move this forward. Is 21 better for you?
No, Your Honor, I have surgery scheduled.
Okay, what's a fair resolution?
30 days, Your Honor.
Mr. Christensen, can you live with a 30-day window? I think you're muted there, sorry.
Yes, I can live with that.
Okay, again, I don't want to be draconian. I recognize we all have many cases. I have over 500 assigned to me. So if 30 days is something you can live with, I think that's great. But I think we need to move expeditiously, and I've given you the parameters to work within. Again, if that conference leads to issues on which you simply cannot agree after good faith efforts, get me on the phone and I'll be on the phone with you within 48 hours of your call. Okay, thank you very much. Court's in recess.
Thank you, Your Honor.
Thank you, Your Honor.